à tous et à toutes. My name is Michael Powell. It's my great pleasure to be a professor here and director of the public law group for this year. We have a fantastic panel for you today to discuss the Notwithstanding Clause. So I really thank them all for coming together at the very last minute. We only started organizing this on Thursday. And things are still happening. This is the stay decision from the Court of Appeal for Ontario. So we're going to talk about the Notwithstanding Clause, but I'm sure we'll get a little bit into, some people are fans of the stay decision. We're going to get a little bit into all the other surrounding issues. So this is the first speaker series event of the year for the Public Law Group. So I did just want to take a minute before introducing the panelists to talk about the others. On October 3rd, we have Dean George Williams and Professor Gabrielle Appleby from the University of New South Wales speaking about Indigenous constitutional rights in Australia, a matter of great debate there. On November 8th, we have a panel on the big standard of review cases which are going before the Supreme Court of Canada in early December, so not to be missed for the admin law fans in the crowd. And in the winter, we have Professor Constance Backhouse discussing her biography of former Supreme Court Justice Claire Dubé. So lots of food for thought in the public law speakers series this year. So without further ado, I'll introduce our panelists. The format's going to be a Q&A, so I get to ask all the tough questions of them, and then we'll move to some questions from the crowd as time permits. So we have Professor Carissima Mathen with us, who's a full professor in the faculty and vice dean academic in the English program, and she is currently finishing a book on called Courts Without Cases, The Law and Politics of Advisory Opinions, which is coming out from Hart Press in 2019. Professor Errol Mendes is a full professor as well at the faculty and editor-in-chief of the National Journal of Constitutional Law, and the author or co-editor of 7 books, including the Canadian Charter of Rights and Freedoms with Senator Beaudoin, among many other honors. So welcome, Professor Mendes. We are lucky to have Gib Van Ert, who is principal at Gib Van Ert Law. He is a public law and civil litigator who practiced for over a decade in Vancouver and now in Ottawa. He was with the Hunter Litigation, one of the top litigation firms in the country in Vancouver. And he served as executive legal officer of the Supreme Court of Canada to 2 different chief justices. And he is working on a new version, I believe, of using international law in Canadian courts, which is a leading text in that area. Professor Vanessa MacDonnell is an associate professor here in our faculty and an expert in constitutional and criminal law, among other areas. You might have seen her testifying to a committee of the House of Commons last night on criminal law reforms. She is currently in the middle of a 3-year SSHRC-funded project on quasi-constitutional law and has recently won the faculty's Emerging Researcher Award. And last but not least, we are very thankful to have Professor James Kelly from the Department of Political Science at Concordia, one of Canada's leading experts on the Notwithstanding Clause. He's written about it over many years.
And I'll defend it.
And he is, by my count, author-editor of 7 books. I might be one behind because you're so prolific, including the very influential Parliamentary Bills of Rights, The Experiences of New Zealand and the United Kingdom, which came out in 2015 from Cambridge University Press. So please join me in welcoming all of our Okay, so just by, you've heard almost enough from me, so just by way of quick recap, we had a decision of Justice Belobaba of the Superior Court striking down Bill 5 from the Provincial Legislative Assembly for being unconstitutional, for breaching Section 2B of the Charter, breaching the rights of candidates, by changing the rules on the number of wards mid-municipal election in Toronto, and breaching the rights of voters by increasing the number of people in each ward from 61,000 to about 110,000. There was Bill 31 introduced in the Legislative Assembly, which included the Notwithstanding Clause, which had never before been used or invoked in any way by the province of Ontario. Today we had the stay proceeding where the Court of Appeal granted a stay, so we are back to the scenario where the province is putting in place 25 wards for the City of Toronto rather than the 47 which were in place at the beginning of the municipal election campaign. So there's been media coverage, which our panelists have participated in, court hearings, flurry of citizen actions, including at the legislature. So I'll start with Professor Kelly, and then we'll work our way down. Why has this particular use of the notwithstanding clause in this issue been so controversial? I know there's lots to say on that.
Okay, well, thank you very much. Thank you for the opportunity to come today and talk about the clause. I think it's, so why is it controversial? I would say the first reason being the Ford government ran on an absent mandate during the last election. I mean, it did not specify what it would do in office. And so to cut the size of Toronto City Council without discussing it at all during an election campaign, I think was controversial, caught people off guard, and I think part of that is why the reaction has been to the extent that it has been. The other reason would be Doug Ford. I mean, I watched the press conference. I was shocked by it. It's not a way to defend the use of such a important constitutional provision. I'll leave it at that.
Professor Mendes.
Well, I want to take a more macro answer to that by basically throwing out, I think people from in my first year con law class knows how much I detest the notwithstanding clause. And frankly, I actually call the notwithstanding clause the fruit of the poison tree. Okay, what I call about that? I mean, one of the advantages I have, apart from my colleague over here, is I think I have more gray. No, you have more gray hair than me. I actually was living in the time where, if you remember, the joint Senate and House of Commons committee had produced the document, the charter, without the notwithstanding clause, at an event which happened not far from here, in a kitchen, in the conference center. An agreement was made between the provinces primarily led by Saskatchewan and Newfoundland to basically put a gun to Pierre Trudeau's head and basically say, unless you actually put this clause into the Constitution, you may not get the substantive consent which the Supreme Court of Canada said you must have to be able to repatriate the Constitution from the UK. And frankly, from my memory at the time, there was even dialogues going on in the UK Parliament to make sure that they would have that consent. So to me, the fact that the majority of Canadians had basically supported a document without the notwithstanding clause, you have this clause now, and you've seen the results of it. Thankfully, at least there was an understanding, and you've seen Roy Romano, Roy McMurtry, and Jean Chrétien basically saying, even with that agreement, it was meant to be in extreme situations only. However, there was no clear understanding in the Constitution itself as to that basic understanding of the notwithstanding clause. So now we go forward all these decades. You see the ability of people to misuse the former understanding of that clause, which was never meant to be except in extreme situations. In fact, the premiers and what's his name, Hugh Segal, who was there firsthand discussing with Bill Davis, the Ontario premier, who was actually not in favor of the notwithstanding clause, basically saying that the type of situations we envisage this is in emergency situations, or where, for example, you have a legislature which wants to have a if you like, a reverse discrimination provision for Aboriginals or something else which has to be put forward. So that was the understanding even amongst those who pushed it forward. However, without that understanding, you now have the ability of people, as the separatist government did, to use it in a way which basically was attempting to defeat the whole purpose. You had Saskatchewan basically applying it to a back-to-work legislation. You had Alberta trying to do it with same-sex marriage. Then you have Ford. And when Ford tries to use this as a way of getting back at people who maligned him in the previous Toronto Council, it clearly shows how we have the emergence of the fruit of the poison tree. And my fear is that even though now they may not use it because the appeal court has said they've granted a stay, and now the government is saying they may not use it, the poison is there and could be used again for, I think, the next one that could be used as a same-sex education one. So we are now starting to have the lingering poison off the tree. So that's why I'm against it.
So we'll pick up on the point on the framers later, because I think that's an important one, and what role, if any, they have to play now. Professor Mathen, why has this been proven so controversial? We got some count on based on history and one based on current political justifications. Are there additional ones? Do you agree with those?
Yeah, so I agree that partly why it's controversial is Section 33 is very controversial. Another aspect, as has been alluded to by Professor Mendes, is that this looks like petty vindictive score settling that is frankly, not just an undignified use of political power. For me, what also made it very controversial were the remarks that the Premier made in his press conference that essentially asserted his legitimacy as a raid against the judiciary's illegitimacy, and saying, I was elected by 2.3 million people, just as a point of actual, the way parliamentary democracy works. That's not technically true, of course. I was elected by 2.3 million people. This judge was appointed. He mistakenly said that a Section 96 judge was appointed by Dalton McGuinty, but we'll leave that aside. The main point is, unelected judges elected me. How dare a judge overrule the decision made by a majority? Well, first of all, judges have been overruling laws, of course, in our country, or striking them down or declaring them invalid since 1867. Since 1982, they've had an expanded judicial review power because we are a constitutional democracy, which inherently subordinates, constrains parliamentary supremacy. It's true Section 33 is there, and we can debate it, but that is the point that I find especially controversial, and the way that we are seeing allies and very long-term allies of Ford and long-term foes of the Charter using this moment to re-invoke parliamentary supremacy. And we should not be fooled by what that means, particularly for vulnerable groups and unpopular minorities in our society.
Ms. MacDonnell.
So I guess the one thing that I'd add, I agree with much of what's already been said. One of the things that really worries me about the Ford government's position is not only that the Notwithstanding Clause may or may not be used in this particular context, but that Ford, in his remarks, indicated that he'd use the Notwithstanding Clause again if he needed to. And it came off as a bit of a throwaway line, but the concern there, of course, is whatever you think of the occasional use of the Notwithstanding Clause, and whether this is an appropriate situation in which to use it, I personally don't think it is. It's a very different thing to suggest that you're going to use the Notwithstanding Clause to push through your political agenda in some sort of sustained way. So you enact a law that's constitutionally suspect, court strikes it down, government responds by invoking the Notwithstanding Clause, or the government just uses it sort of preemptively. That kind of specter of government by Notwithstanding Clause, I think, is really disturbing, because whatever this clause was intended, whatever purpose it was intended to serve, whatever legitimate use it might have in particular circumstances, this would be certainly not what had been contemplated in inserting this clause. I also think that inevitably it would be very damaging to our constitutional democracy, to individual rights, to the relationship between the various branches of government. So that concern, I think, is still out there, notwithstanding, no pun intended, notwithstanding this morning's decision, which in staying the trial decision pending appeal, the Ford government indicated, that they would not pursue the legislation any further now, this new legislation that they've introduced. But I think now we have to be looking forward to what's going to happen next, and has a bit of a precedent been created, or will we see the Ford government use this clause again when it encounters opposition to its policy agenda?
I think this whole episode has illustrated how deeply the notion of charter rights has taken root in our society. It's not even 40 years now since we've had the charter, And yet there seem to be a lot of people in this country who now regard those as sort of a possessory interest of them as individuals. And Section 33, when you read the Charter, doesn't treat them that way at all. Section 33 seems to imply that charter rights exist on the sufferance of the federal parliament or the provincial legislatures, who can take them away, at least the ones that are subject to Section 33, so Section 2 rights, which are pretty fundamental, and Section 7 and 15. Reading that, if you landed on planet Earth from some foreign place and read Section 33 and the rest of the Charter, you might conclude, well, this is an interesting arrangement for protection of rights, but it's got a very significant qualification, which is that legislatures have a clear power to just suspend, at least for 5 years at a time, a lot of these very basic fundamental rights. And yet, that isn't how I think a lot of Canadians imagine their charter rights. I think a lot of Canadians imagine that they really are our rights and that they don't exist on the sufferance of legislatures. And the notion that the Notwithstanding Clause might be used by the most populous province in the country in a situation that isn't, as Errol says, one of urgency, or even one that's terribly compelling or introduces other competing values that might be said to be on a par with human rights considerations, that has shocked a lot of people. And I'm very sympathetic to that. I find it shocking too. I'm going to put you on the spot a little bit, all of you. So just very briefly, and then we'll move into a deeper question. Do you expect that this is going to be a one-off in Ontario or elsewhere, or have we, I'm asking you to speculate, or has the door been opened a little bit? I mean, maybe some of that depends on public opinion and the reaction of the legal community and of voters, but do you think, Professor Kelly, starting with you and going down the road again, are we in a new era, or was this a one-off?
Well, it's a no-off. I mean, it wasn't used. I mean, we have to keep that into perspective, right? The government introduced a bill wanting to use the Notwithstanding Clause, but that has now been jettisoned. So again, I'm not particularly concerned about it being regularly used. There's no evidence that has ever been the case after a use of the Notwithstanding Clause. If we think of Ford versus Quebec, why was it not used by the Bourassa government? Because it suffered extreme chastisement by the rest of Canada, but also within Quebec. And we have to keep in mind that, I mean, the Bourassa government lost cabinet ministers. It lost nearly, I think, 8% of the vote in the next election. It led to the rise of a new party, the Equality Party. So I think what we have to keep in mind is that perhaps, I mean, the judiciary is not the only check on the arbitrary use of political power. And I'm interested to see what the next set of public opinion polls in Ontario say about this. Now, if the Ford government suffers a drastic drop in support, I'm thinking that's perhaps think of Brian Mulroney, the magnificence of our judiciary. That might be the magnificence of the Notwithstanding Clause. It's a political tool, and governments use it with extreme caution. And the Bourassa government's experience with using the Notwithstanding Clause, for me, sort of tempers some of the concern about widespread use of the Notwithstanding Clause. And speaking before the panel, I recognize that Doug Ford is not Robert Bourassa. And you know, in preparation for this, I was reading Bourassa's defense of using the Notwithstanding Clause in the context of Ford. It's a principled decision, a powerful statement about the leader of a particular government in the North American context. So again, I'm not equating these two individuals. What I'm suggesting is they both operate within a parliamentary system, and there are other checks. And I said what I'm interested to see is the level of support decline, if any, for the Ford government. Because again, this is a new government. Many of these individuals won their seats for the first time, and public opinion polls tend to constrain what governments do. And I'd like to see in the context of this particular example.
One-off, a new fact of life, or a no-off?
I want to agree with my colleague, but I think we live in dangerous times. When you see what's happening down in the United States, when you see populism is essentially basically saying saying to people who feel they have power that because you have the theoretical power to do whatever you want to do to ignore what are called the norms in society, you can go right ahead. And seeing how in the United States, in a populist era, that the president is undermining all the established norms, from using the presidency to accumulate wealth, etc. Do you not think that our present leaders, especially those who see his success, may not follow the example? And the norm that we thought we had, that the notwithstanding clause should be used only in extreme situations, has been dispensed with on this occasion, and that there's a habit of getting used to breaking norms. And my fear in these dangerous populist times we have, if there is a political advantage to use it again with the same-sex education, my biggest fear is going to be used again. So we live in extraordinarily dangerous times right across the world. You're seeing the same thing happening in Europe. I just came back from a sabbatical in Italy. You see it there too. We live in extraordinarily dangerous times right now.
I hate to continue the pessimistic trend, but I tend to agree with that. So whether it'll be used again, I certainly think he'll be very tempted to use it again. I mean, he will not take the lesson from this, which is there but for the grace of God, I didn't have to use it. He will think, I used it and the court blinked. That's what he's going to think, or I threatened to use it. And I actually don't, just because it's true, he has said, or his government has said they won't use it. To me, this is a virtual use of Section 33 when you think of, just think of what was going on in the Ontario legislature the last 6 days. So I think he will be very tempted to use it again. I have always thought that the norms that undergird our society and our politics are really dependent upon a certain mindset and culture of our political leaders. And they are the ones that bear a huge responsibility for explaining or demonstrating what the rule of law is. I will respect this court decision, which does great damage to my political interests, because that is the essence, that is a pillar of our society. And if you have someone who is willing to subvert that and to explain it in very crude power terms, our society is sufficiently stratified that there is a significant portion of the electorate that will be swayed by that. Because explaining why unelected judges get to do what they do is actually not that easy to do. So also, this is where, in a sense, we are worse than the United States because we don't directly elect our chief executive. So we do not actually have the ability for the population as a whole to render a verdict. We have the parliamentary system where a relatively small band of committed voters can achieve an imbalance in the political result. So different times, definitely not a Robert Bourassa, and there's our politics are getting more tribal, and if you have leaders that are willing to exploit that, I mean, again, I don't think that we should shield ourselves from the possible consequences of that.
Quickly, I think there is, I'm not sure, I think it's probably more likely than not that he will try to use the clause again. I absolutely agree with Professor Kelly that much depends on how the public responds to the use of the notwithstanding clause. If he suffers politically for it, and because he didn't go all the way through with it, it's a little bit difficult to gauge what the political response was ultimately. But I think if there's a very negative political reaction, if it's viewed as being politically risky, then I have the sense that that's something that Ford will likely respond to. The one thing that does concern me about these political mechanisms of accountability, though, is I see a lot of very competent ministers around Ford. Ford himself may be unpredictable and sort of committed to his own political agenda, regardless of what the law, the limits the law imposes on him, but he's got a lot of intelligent people around him who do know, and I think should have an appreciation for the limits that the law places upon this government. And I become very worried when I see I guess some of this is just cabinet government, but I see a very unified cabinet supporting Ford in what to me seem to be kind of ludicrous arguments, political arguments about the use of the Notwithstanding Clause. So I think that further, and you have right now a weak opposition numbers-wise, so I think it really will be important for the public to express their disapproval of this use of the Notwithstanding Clause.
I think, as Professor Mendes said, there's a populist turn in politics all over the world right now. It's not just Donald Trump in the States. It's going on in Europe. It's going on in the UK, and we're not immune from it. And I've been concerned for some time that one way in which that might manifest itself in this country is by a sort of populist run at the judiciary. Judges are very susceptible to being mischaracterized as elitist, as illegitimate, and they are peculiarly badly placed to defend themselves. In fact, they rely on us as lawyers to come to their defense. And I think that's going to be very important. It's always important, but I think it may be more important in the years to come. One way in which you could deploy Section 33, I'm not saying that Mr. Ford would necessarily do it, it could come from all sorts of places in this country, would be as the rhetoric that would surround that use could be, we're going to show the judges, we're going to reassert our own superiority over the judicial process. We've seen a bit of that, I suppose, in some of the rhetoric from Mr. Ford already. There is a risk of that, I fear, that may prove hard to resist. I'm not sure that we're out of the woods on this. To the contrary, it feels like we may have just moved into them.
So we've had heard different views on how likely it is the Notwithstanding Clause will be used in the near future. And Professor Cobb's absolutely right, has not actually been used here, apart from being invoked in Bill 31, which has not passed. But it's raised the question, if it is going to be used more often, are the courts likely to find there are any substantive limits on how or when it can be used, or should they? Right? So some people have talked about shouldn't Section 33 be permitted to be invoked in an arbitrary fashion. Some people suggested an Oakes-type test on the use of Section 33 would be read in by the judiciary. Others have said this is deeply incorrect for the courts to limit something that the constitutional text particularly gives to legislative bodies. So maybe starting with Professor MacDonnell,
Sure.
because I know you've commented in the media a little bit on this. Should the courts do it, and is it likely to happen?
Right. So one thing I might just start by saying is that there are kind of two different ways of conceptualizing Section 33. There's one that's kind of the default way of understanding the section, and that is to say that when the government invokes Section 33, what they're doing is suggesting that the law they're proposing likely infringes constitutional rights, but that they're proceeding notwithstanding the Charter, right? So some sort of tacit acknowledgement of constitutional, possible or probable constitutional infirmity. The other way of conceptualizing Section 33, and admittedly this emerges more from the writing of scholars than from the jurisprudence of the court, and there has been actually just very little case law on Section 33, is to say that when the government invokes Section 33, what they're doing is suggesting that they disagree with the judicial interpretation of, or the judicial resolution of the issues in a particular case. So in the context of this city council issue, you could say, well, maybe what the Ford government is doing here is suggesting that on a reasonably defensible interpretation of the Constitution, this law was actually constitutional. They disagreed with Justice Belobaba and his finding of constitutional invalidity, and they're going to invoke Section 33 to insist upon their interpretation. So that's what we call a theory of coordinate constitutional interpretation, which is The courts have a role to play in interpreting the Charter and the Constitution, but so too do political actors. So I think the answer to this question depends to a great extent on what vision of Section 33 you adopt, right? I'm actually partial to this idea that there is a space, and the Constitution provides that space for the government to insist upon its interpretation of constitutional rights. And part of why I'm attracted to that argument is I'm not so keen on a section on characterizing Section 33 as allowing the government to just deviate from charter rights if it suits their political agenda. To me, I think if you want the charter to read coherently, you need to understand Section 33 as being part of an overall project of rights protection. And if that's the case, then maybe the government should be able to insist on their view. In this particular case, actually, there were lots of people who were skeptical about the constitutional arguments that were raised in this case. In fact, this morning, the Ontario Court of Appeal, in granting stay pending appeal, stated in fairly strong terms that Justice Bello-Baba was likely mistaken in his conclusions. And I suspect when this is heard on the merits that we'll see the Court of Appeal overturn the trial court. So this actually is the kind of situation where maybe there was a reasonable disagreement. The problem, of course, is that's not what Ford said, right? It's not what he said in his press conference. It's not what his ministers have said on the floor of the legislature. What they've said is this is about efficiency, expediency, about value for money. He hasn't said we have a reasonable disagreement with the courts. We've heard them. We respect the courts. But respectfully, we're going in a different direction. And so I like to think that there is a space for thinking about the Constitution in this, or Section 33 in this kind of rights-enhancing way. If you're thinking about it in the traditional sense, though, are the courts going to impose substantive limits? I have a very hard time imagining them doing so. If they did, frankly, I think they would be open to criticism. I think the accountability mechanisms here are political. And that means the ballot box, that means citizen engagement, that means opposition members in the legislature holding the government to account. Those, I think, are the accountability mechanisms. I think if the court steps in and uses really creative legal arguments to assert itself, that's not going to be good for the court's legitimacy.
Professor Kelly is smiling, so I think he has something to say on
I
that.
do.
Should there be substantive limits, and is the court likely to find that there are some if the notwithstanding clause is invoked more frequently?
Well, thank you. I'm gonna invoke Peter Russell, professor of mine from the University of Toronto. And he wrote an article, I think it was around 1990, called "Standing Up for Notwithstanding," and that's what I'm going to try and do today. Notwithstanding Doug Ford, right? But let me go back to I think what the events of the last 10 days or so illustrate is that we really don't understand what Section 33 is.
Yeah.
And I've been reading the media comments about it's the nuclear button, it's a loaded gun. I don't think that is particularly helpful. But what is Section 33? I mean, as a political scientist, it is when a government registers its fundamental disagreement with a judicial decision. That should not be equated with overriding charter rights. Because when a piece of legislation is invalidated, it's because the court has determined that the limitation is not reasonable. That's not overriding the charter. So again, I think the events of the last 10 days we have to think what Section 33 says, and I think that's been lost. In terms of judicially imposed limits on Section 33, I would say absolutely not. And the reason that I would say that is I understand the need for judicial review if a constitutional provision is ambiguous in its writing. Take Section 2B, freedom of expression. And the justice decision was rebuked by the Court of Appeal, how he had stretched that into the electoral process. If you read Section 33, it is crystal in its clarity how it should be used. So I don't believe that there's any justification based upon a principle of judicial review in terms of clarifying constitutional ambiguity that could be used and should not be appropriate. I'd like to turn the question around. Would it be appropriate?
I don't have to answer that.
Would it be appropriate for Parliament to attach limits on Section 24.1? And the reason that I'm asking that is Section 24.1 is clearly assigned to judicial actors. Section 33 is clearly assigned to the legislature and Parliament. And because of that, I think it would be inappropriate and unconstitutional for either to attach limits on either Section 33 or Section 24.
Do you think Section 20 remedies for breaches of the charter for the first-year students?
Definitely. Oh yeah, I mean, I'll tell you, know the remedy I hate? Judicial amendments.
Yeah.
Right? I would remedy that.
That's not what they call them, though, right?
Reading in.
Reading in.
I think we got Professor Mathen and then Gib.
Yeah, I have to push back on the view that Section 33 is really about the government registering its disapproval of the judicial decision, because on the face of it, Section 33 does not require as a precondition any judicial decision. It can absolutely be used preemptively. It has been used preemptively, and in that case, I just don't think it's accurate to view it as anything other than suspending the operation of the charter, of certain sections of the charter with respect to judicial review. So it can absolutely preempt judicial review on its face. I guess another point I want to make is that a constitution does not always allow of coherence in an analytical sense. Constitutions are products of politics, and they often embody political compromise. You can see that with respect to the rights accorded to denominational schools, which on their face would appear to conflict with the rights of equality and the meaning of freedom of religion, and that has been clearly upheld by the court as that's just the way the cookie crumbles, and that's the way the Constitution has been designed. So I just want to put that out there, that it is not always possible to force the Constitution into a coherent relationship vis-a-vis its own internal decisions. I agree that it would be dangerous for the courts to read in what essentially would be proportionality or justificatory elements into the use of Section 33, which for one thing to me would seem to utterly duplicate Section 1. And second, would really be asserting judicial supremacy over an area where it seems to me there is a space for legislative supremacy. And I think at that point, the point at which its invocation becomes routine or it becomes used in ways that we really regard as unprincipled, the courts are not necessarily what is going to save us. Right? So it is a political battle. It is a battle about norms. The courts have a role to play at some point in the process, but by that time you are talking about the kind of social divisions. You know, if those of you who are familiar with American history, the Dred Scott case, Chief Justice Taney truly believed that by essentially constitutionalizing slavery, he could prevent political breakdown, and we all know what happened. Or he in fact was utterly ineffective, and if anything, actually aggravated the political situation. So, you know, we cannot always expect the courts to resolve these kinds of disputes.
So, Gib, you are enjoying your return to civilian life, partly on your Twitter feed, which I recommend to everyone. But you did advance on Twitter a possible limit on the use of Section 33, which is international law. So if you could explain that argument, that would be fantastic.
Sure. Well, let's back up first. Is Section 33 subject to judicial oversight? We know from the Ford decision that it's at least subject to some, because the court did say that retrospective application wasn't permissible. But on balance, I think when you read the rest of Ford, it seems to be saying this is a judicial no-go zone. Now, but that was 1988, and how would it be decided today? I don't know. I'm not sure that it would be the same way. So let me give you a hypothetical, which I think we will all agree is outrageous, but I think it's also available. So if a government, provincially or the federal parliament, wanted to suspend the right to religious observance for some particular religious group for 5 years, on a plain textual reading of Section 33, you can apply Section 33 to suspend Section 2A rights for up to 5 years. So imagine a legislature enacting the Prohibition of Muslim Worship Act 2021. And for 5 years, no Muslim religious worship is permissible in that jurisdiction. If you think that Section 33 creates a judicial no-go zone where, so long as the legislation has been properly enacted, the legislature has the power to totally disregard the right that is being restrained, then you're really not going to care what international law has to say about it. And maybe that is the right interpretation of Section 33. If it's the right interpretation, what I'm saying is maybe it's the right interpretation as a matter of Canadian constitutional law. It's very clearly illegal in international law. And I suspect that that conclusion would worry judges a lot, at least I hope it would. Now, I only raised that. It's a bit of an in terrorem example, I hope. But I raise it to make the point that it seems to me inevitable that there is some room for judicial oversight over Section 33. Now, in a case that's less stark than that, and probably the case that will come before the court one of these days, whether it's a few years from now or a few decades from now, will be less stark than that. But in principle, it seems to me extremely unlikely that there is no judicial oversight of a provision of the Charter, Section 33. All right, so if you accept that in principle there may be some room for judicial oversight, then the question is, well, what are the standards against which you measure judicial oversight? Is it, and we've talked about, we've heard, well, maybe the judges would have to invent something. There would be some creativity required. There would be some innovation required. And I agree with people who have said any sort of creativity or innovation risks putting judicial legitimacy in play. And I don't think, generally speaking, that judges like the idea of being creative or being innovative. I think they prefer the idea of applying pre-existing norms that they did not invent, but that were already settled. So are there any pre-existing norms that speak to the derogation of human rights and that courts could look to in a proper case where Section 33 was used? The answer is yes, there are. In the mid-1960s, the states of the world got together in the International Covenant on Civil and Political Rights and codified when it is lawful for a state to derogate from certain civil and political rights. And the states, including Canada, of course, at the table, agreed that in a case of national emergency, public emergency, where it was necessary to do so and where the rights derogation was limited to what was necessary in the circumstances to meet the emergency, some civil and political rights can be suspended. Not all of them. The right to life can't be. The right to freedom of conscience and religion can't be. The right to freedom from torture can't be derogated from. But freedom of expression, for instance, could be derogated from where there is an emergency. That's what, and by the way, there are 168 state parties to the ICCPR. So this is as close to a universal legal norm as we have on planet Earth. Canada acceded to that treaty in 1976 and has since told the United Nations on at least 3 occasions that I'm aware of that Section 33 could not lawfully be applied by Canada except in conformity with Article 4. And has even told the United Nations that the Supreme Court of Canada's own jurisprudence says that charter rights are to be interpreted as conforming to our international human rights obligations, at least protecting human rights at least as much as international law does. We can protect them more, but we can't protect them less. Canada itself has told the UN that. So the attraction in this, to me, is that it doesn't require judicial creativity. A judge confronted with, do I have any power to judicially review a Section 33 exercise, can say, well, the states of the world have agreed upon when it's lawful to derogate from international human rights law. The Supreme Court of Canada has said that the Charter protects international human rights, or protects human rights at least as much as international law does. And therefore, I've got the building blocks for a legitimate judicial review of an exercise Section 33. Now, having said all that, I don't say that this is easy. There's a huge discrepancy between what Section 33 says on its face, which is that you can derogate from freedom from torture, Section 12, to freedom, right to life, Section 7, freedom of conscience and religion, Section 2A. On the face of Section 33, you can derogate from all those things. So on its face, Section 33 is inconsistent with Article 4. And that's a serious objection. I don't mean to downplay that. But the virtue of this is that it doesn't require judicial creativity. It requires courts to do what the Supreme Court of Canada has said we do already, and which the Government of Canada has told the UN we do already, which is to interpret the Charter in conformity with our international human rights obligations.
Professor Mendes, I know you've got a plane to catch soon.
Oh, that's okay.
This is more interesting.
I wish I could agree with the possibilities, but I tend to agree with Carissima that there would be extreme caution for the judges to think that they can amend Section 33. Although I should say the one area where I think Gibbs' analysis is appropriate, but on a much more historic basis. Yes, the court in Ford did say that the one principle which does apply to Section 33 is the retroactivity principle. Now, why would they say that? Well, that has about 1,000-year history. It goes all the way back to the Magna Carta. Okay, so that's where that level of importance is triggered by Section 33. However, I still think that it is important to keep on remembering that the Charter is not a product of premiers, or for that matter, I mean, apart from the Prime Minister who pushed it. It was the product of people. For those who were living at the time of the joint House of Commons Senate Committee, as I was, it was the highlight of Canadian patriotism and citizenship, where from coast to coast, people from every single part of Canada, every single identity group, a community, a multicultural group, came together to try and create this document called the Charter. And the only reason why Section 33 was imposed, in my view, was that there was a constitutional gun to the head of Pierre Elliott Trudeau. But given that, what else is possible? And I think that we haven't been creative enough to think about what else is possible to move a little bit back from that constitutional gun. Well, what about that type of solidarity that we saw in the 1980s, 1981, 1982, which could come back to protect the Charter? We've seen examples of how governments have been restrained by, for example, when Canada was in danger and we almost lost the country by 50,000 votes, there was at least a desire to put something through the House of Commons to have, if you like, a recognition that Quebec would have some say in any future constitution. So we had the regional veto resolution. Maybe it's time for Canada to start thinking about another approach by Canadians and provincial legislatures and the federal parliament to pass similar resolutions about how the Charter of Rights should be protected under Section 33. And I encourage every single one of you, if you like that idea, to propose it to your MPs and your MPPs too. That's my idea in terms of protecting this Section 33.
We've got last word on this question,
Yeah,
Professor.
very
Another
quick.
30 seconds.
Yeah, sure. Just the difficulty I have with Gibbs' argument is I imagine that if a court, certainly the Supreme Court, were ever to attempt to impose substantive limits on the use of the Notwithstanding Clause, relying on international law, we might face like a kind of wide open political revolt. And what I'm thinking back to is the Cotter case, I think 2010, because I want to just make the point that courts are very conscious of the political implications of their judgments, and the Supreme Court in particular. In the Cotter case, 2010, the Supreme Court ultimately, the question was, I'll stylize it a bit, but does the federal government have an obligation to repatriate Omar Cotter, given their involvement in ongoing human rights violations against him at Guantanamo Bay? And the court found that there were ongoing constitutional obligations. In the circumstances, it looked like the only thing they could do to actually cure those constitutional violations was the government was to repatriate Cotter. But the court did not order that he be repatriated. They went with a much softer remedy. They basically declared that there was this ongoing violation of rights and said to the government, now you've got to do something about it. And my read of that was they were very concerned that if they ordered him returned, the government might say no. And if the government doesn't listen to the Supreme Court on a remedial matter, then you've got a constitutional crisis. And I imagine that in a Doug Ford world, if the Supreme Court were to rely on international law to impose substantive limits on Section 33, then you may well end up with a situation where the government would just say no. And I think the Supreme Court would take that into consideration. I think that would just, like politics, essentially, would mitigate against that kind of an approach.
Okay, so I'm conscious of the time. Last question for me, because I want to make sure we get comments and questions from the crowd. So we are in a law school. A lot of my first year public and constitutional law students are here. We learn about dialogue theory, right? The idea that courts and legislatures are in a dialogue with one another that involves Section 1, the Oakes test, that involves Section 33, the Notwithstanding Clause, remedies, which have come up a couple times on the panel. So starting with Professor Kelly, has this incident shone dialogue theory in a new light? Are your previous views on dialogue theory reconfirmed? And then just a minute and a half, we'll go down everyone along the panel here. Thank you.
Okay, thanks. Well, I want to say I love dialogue theory because I got tenure out of it.
Disagree with.
No, I didn't. And but I'm not actually. I wouldn't classify myself as a dialogue theorist anymore. Another point. I think what this shows to me is, I mean, political scientists have always been skeptical about legal academics' commitment to dialogue theory, because our perspective has always been that to be a dialogue theorist, you have to accept the legitimacy of Section 33 as part of the dialogue. And again, I'm not defending what the Ford government did. In defending the Notwithstanding Clause, I would suggest that it should only be used after the Supreme Court of Canada has ruled. It should never be used on a lower court decision. It should be the very end of the process. That being said, though, sort of the rejection of the Notwithstanding Clause the last 10 days has reinforced to me that position that dialogue is always being a judicially centered dialogue. In terms of the debate. And just to finalize on this, it's led me to think about a new article perhaps I'll write. You think of the original Hog and Bushel article, the charter dialogue between courts and legislatures. Or perhaps the Notwithstanding Clause is not such a bad thing after all. And I'm going to send it to Errol.
National Journal of Constitutional Law.
I'll send it back with red marks.
All right. Confirming the thesis. But again, I think it shows to me the lack of commitment to a full dialogic approach to the charter. The debate on Section 3.
Dialogue between political scientists and legal academics. Professor Mendes.
Well, actually, I think that in a way, strange sort of way, the appeal decision that just come out on the stay motion has actually introduced a new dialogue theory, but not between the courts and politicians, but between the courts teaching the Premier the basics of democracy, frankly. That, yes, there is such a thing called appeal systems, which can basically assess whether or not the first level system is correct in its application. And maybe if anything could come out of that appeal decision, and perhaps the future full appeal decision, is to tell Premier Ford he cannot keep on doing what he's doing in terms of undermining the judiciary. That would be a great dialogue.
Professor Mathen.
I really hate dialogue theory. I think it's empty. I think it's largely been a way for courts to shield otherwise very robust remedies. I think it's dangerous to view Section 1 as engaging any kind of dialogue as opposed to a duty on the government to demonstrate, or the government to demonstrate reasonable limits. But if you're going to buy into dialogue theory, then Section 33 is the purest form of dialogue theory there is. So I'm not sure that a lot of dialogicians would like that, but that's my take. I don't think dialogue theory is useful at all.
I just say that I think implicit in this idea of dialogue is listening to each other, to deliberating, considering the reasons that have been offered for a particular view of what the Constitution requires in the circumstances. And one of the things that I think appears troubling in this circumstance is that there doesn't appear to have been much listening or dialogue or justification. Now, I don't think the Section 33 move came up Monday morning in Cabinet after the decision was released. I suspect that this had been in the works for some time. But I think dialogue means public justification, right? You've got to have an actual discussion, and you've got to be reflective. And so what does this mean? I think it may confirm Carissima's suspicion that this is an empty concept, and really what we're talking about here is political maneuvering and not some sort of high-level enlightened dialogue on what the Constitution requires.
I agree with Carissima. I don't know that courts recently have been talking about dialogue very much. Judges have a job to do, which is to defend and uphold the Constitution. And I don't know that that is a dialogical process. I think that's a process of interpreting the statutes, interpreting the Constitution, doing your job. And judges, I've had the good fortune over the last few years to get to know a lot of them, and they take it immensely seriously, which is good news for us all. And they're very serious-minded about it, and as they should be. So I don't know that it's a terribly useful theory anymore.
Okay, thanks to all these.
Mike, do you want to get in on it?
No,
I know. I think dialogue theory just got a thumbs down from the entire panel.
I'm your humble moderator. We need to take some questions from the crowd. Si vous voulez poser des questions en anglais ou en français, comme vous voulez. Ici, premièrement.